Hello, greetings, and welcome to the session on pretrial proceedings in the age of COVID. My name is Jeremy Fogel. I am a retired judge of both the state and federal courts, currently the director of the Berkeley Judicial Institute at Berkeley, which is one of the co-sponsors of this program. And for 7 years immediately prior to coming to Berkeley, I was the director of the Federal Judicial Center, which is the research and education agency for the federal courts. I'm pleased to be joined by a panel of people who span the range of interests in pretrial matters. We have two very distinguished advocates, one who primarily does plaintiff's work, another who primarily does defense work. We have a judge who presides over a high volume of civil cases in a state court docket. And we have a law professor who's done a great deal of research and theoretical thinking about civil justice. And without further ado, I'd like them to introduce themselves. So let me start with Janet Aberre.
Good afternoon. I'm Janet Aberre with the law firm of Berg Simpson. I'm in the Cincinnati, Ohio office, and my practice area is primarily products liability and complex litigation, and we practice really around the country. Obviously, cases here in Cincinnati and Hamilton County, but also in federal court particularly, but also some state courts throughout the country.
And if I understand correctly, you've done a fair bit of MDL work and are familiar
yes.
with complex litigation as well as individual cases.
Yes, I've been lead counsel on some MDLs involving medical products and devices and prescription drugs.
Great, thank you. Next, I'd like to introduce Judge Sandra Pearlman from Fort Lauderdale, Florida. Judge, you want to tell us a little bit about what you do in this space?
All right, good morning, everybody, or good afternoon here in Florida. My name is Sandra Pearlman. I'm a circuit court judge in Broward County, Florida, also known as Fort Lauderdale. For those of you who haven't been here, it's halfway between Miami Beach or South Beach and Palm Beach. I'm a circuit court judge. I do general civil cases. Before I took the bench in 2011. Before I took the bench, I was an assistant public defender for almost 20 years. And in the end of my career, started specializing in death penalty litigation. In the meantime, or in between that, I took the California bar. I moved out to San Francisco and started with a small firm, and then I missed the courtroom. So I started a job with the Santa Clara District Attorney's Office. I consider myself an honorary San Franciscan because I was in San Francisco during the 1988 earthquake, and I was actually at what we now call the Earthquake World Series. So it's nice to be back in the Bay Area. Thank you for having me.
Thank you. And your docket right now is exclusively civil, correct?
Exclusively civil. I have about 2,500 cases.
Okay, great. So I think we're ready to go with Mr. Lifflin. So Charles, why don't you tell us a little bit about your practice? You're muted.
Yep.
There you go.
Thank you. Getting the hang of this. My name is Charlie Lifflin. I'm a partner with O'Melveny & Myers. I'm based in Los Angeles, but like so many others, I'm working almost exclusively out of my house, and I've been doing that for the last 6.5 months in Pasadena, relying on Zoom and telephone and the like. I've been at O'Melveny for 37 years, which I guess qualifies me as an old timer. I've also been privileged to be on the RAND ICJ board for the last 15 years or so. My practice is complex litigation, typically on the defense side. I've covered a lot of areas over the years, including antitrust, securities, class action, and appellate. But my major focus over the last 25 years has been mass torts of various stripes. Most of that work has been in pharmaceutical cases or environmental cases. For the last couple of years, the case taking most of my time is the national opioid litigation, where I'm the lead national counsel for Johnson & Johnson. Obviously, that's not a typical case. There's 3,000 cases brought mostly by state and local governments against a large number of defendants, really across the entire industry. You have pharmaceutical manufacturers like J&J, you have distributors, you have pharmacy chains. The federal cases are all MDL'd in Ohio, though some have been farmed out as bellwethers for pretrial elsewhere, including one in San Francisco before Judge Breyer. There's also active litigation in many MDLs in more than a dozen states and in other individual state cases. So it's very challenging and not at all typical, but it does provide a fairly broad window into pretrial practice under COVID. Since the lockdown 6 months ago, we've had no trials, but we've had ongoing depositions, document productions, remote status conferences, motion hearings, settlement conferences, interlocutory appeals, you name it, in lots of different jurisdictions. So I'm looking forward to our discussion.
Thank you. And you just provided a great laundry list of some of the things we're going to talk about. So thanks for that. And finally, Professor Scottdson from UC Hastings. Scott, you want to tell us a little bit about your interest in this topic?
Sure. Thanks, Judge. As you said, I'm Scottdson, a law professor at UC Hastings College of the Law in downtown San Francisco, where I research and write on federal jurisdiction and civil procedure. I haven't been directly involved in any litigation during the pandemic, but I recently co-authored a paper with Judge Lee Rosenthal and a litigation partner in Houston called The Zooming of Federal Civil Litigation, which will be published in Judicature later this fall. So I'm very much looking forward to being on this panel and having this discussion.
Great, thank you. So we've got various perspectives to bring to bear. And the way we're going to organize this session is we're going to talk for a little bit about some of the positive things that have happened from the perspective of the panelists as a result of the adaptations the courts have had to make to COVID. We'll talk also about some of the negative things from their perspective that have happened. And then we'll kind of try to draw those threads together at the end and talk about what we've learned and how we might use what we've been experiencing during this period to make the courts better going forward, things that are worth keeping as permanent transformations of our system. And as Charlie cataloged, there's a lot of aspects to pretrial proceedings. The three that I thought we might want to talk about, and in no particular order of consequence, is discovery, various interactions with the court. It could be case management hearings or status conferences or motion hearings, and the whole process of settlement as it exists in this particular era. So let me start with Janet, and you could talk perhaps about, you're a plaintiff's lawyer primarily, and you've done big cases, you've done little cases. How has the pandemic impacted your work in ways that you consider positive, things that have been actually improvements over what existed before?
I would say the biggest positive outcome so far is we're much more efficient. We've cut down on travel costs significantly. Obviously, I haven't been anywhere since February. And before that, I was constantly at airports and, million miles on Delta. We travel all the time for hearings and depositions. So the fact that we aren't doing that traveling is saving time and money. And for the most part, I feel in this phase of litigation, it hasn't been detrimental to the case. With the earlier panel was talking about trials themselves, which is a whole different ballgame. But for what we've been doing, we've had a lot of arguments with the court on discovery matters or motion practice. That's gone very smoothly. I will say for the most part, it's just been by telephone. We haven't had a lot of these Zoom kind of procedures. I had one case where there were Zoom hearings and Zoom participation in a bankruptcy proceeding in Texas. But I actually had one day where we were taking a deposition in the conference room. I'm in Cincinnati. The witness was in California. The defense counsel was in Chicago. The other questioner was in New York. As we were doing that deposition, I walked down the hall, went into another conference room, attended a pretrial conference with the judge in New York, hung up from that and got on another call with a committee that was out of Texas. So I did all that in an hour when normally it would have been days. The other thing where it was a big advantage is we did have some emergency motions come up with a defendant that filed a bankruptcy. And at the time all that was going on, I should have been flying to a hearing across the country, which was switched to being a phone hearing. And by virtue of that, I was able to be on the spot to work on the other issue. So we've seen a lot of efficiencies from doing things. As I said, mostly it's been by phone.
Mm-hmm. I don't know whether this would go in the positive or the negative category, but how has this affected your relationship with opposing counsel?
That's a really good question. And one thing I've been thinking of is the first case that I was talking about that was in New York. We had our initial hearing in person. It was, a year or so ago. I got to meet the judge. I got to meet opposing counsel. They met me, we had a chance to have a dialogue. So now when I get on the phone with that person or with that judge, we all know who each other is. We've had that acquaintance. I think it's going to be a lot harder, and I did find it a lot harder with this case in Texas where the judge knew a couple local attorneys but didn't know everybody else. And I do think that's a really big issue. Mm-hmm. Now, in that case, the Zoom helped a little bit, but I think there's a problem and a negative when you haven't had that chance to have a personal acquaintance. Right.
So the thing that made it work in the first example you gave was that you had a pre-existing relationship with
That's
counsel. Right.
Is
it any different in the MDLs where you have management committees and steering committees and things like that? I mean, is this medium helpful in that regard?
Well, when we do MDLs, one of my co-counsel used to joke that we were like the British Empire, the sun never set on our committee because we were spread all over the country. So that's always been done by telephone and remotely. But most of the times you would have monthly or bi-monthly in-person conferences with the court. And at those opportunities, you get together and you do get to see your co-counsel and you do have sit-downs and in-person with opposing counsel. So I do think that informality and the familiarity, that lack of that interaction is going to take a toll.
Right. Okay, we'll come back to that. Thank you. And there's one other thing I wanted to ask you about before moving on to Charlie, and that is to the extent you've done settlement, you've done mediations or settlement conferences or anything of that sort during this 6 months, would you say that that's on the positive or the negative side?
Well, the biggest negative is nobody wants to talk about settlement because they don't have a trial date. So the whole COVID thing, first of all, just pushed everything back by months. And then it's just been, I don't want to say an excuse for delay because I'm sure from the defense perspective, it caused delay, but it's, we can't get in to look at the documents and we can't do a search and, so-and-so can't get to their computer. So everything is stretched out. It's prevented really moving forward on settlement. Now I have a case where the defendants did contact about doing a mediation of class action, several hundred plaintiffs. We're going to do it in person. And everybody talked about it. We agreed on a location. And I basically said, look, I'm willing to travel, but I'm not willing to fly. So we're going to accommodate a location where the defendants already are. I can drive there and the other people are going to fly in. So people have cooperated.
From what you've said so far is that the biggest positive has been the efficiency. You're able to use your time more effectively. Yeah.
Yes, and expense.
Which helps the clients too. Yeah.
Yes, it sure does.
Yeah. Okay. Charlie, same set of questions for you. What have you liked best about this period of time? If assuming that there is something.
I'd have to echo a lot of what Janet just said from my perspective. I mean, the huge difference for me is less travel. I mean, and that's a good thing generally. I'd hasten to say no travel is a bad thing, but less travel overall has been a positive, I think. Given the nature of the opioid case, I was literally on the road for 6 months out of the last 12 months in 2019. And so, less travel means less wear and tear, less dead time, less expense for the clients. Of course, less time away from family. Those are all good things. You certainly lose something by not having the in-person ability to interact with people and some important things. But I found that a lot of what we do, especially in pretrial, trial I think is a different can of worms, but in pretrial, a lot of what we do can be done efficiently remotely. I agree that it really helps to have pre-existing relationships with the judge, with the opposing counsel, with the co-defense counsel, with the witnesses, if you're working with witnesses. And it would be much, much harder, I think, without that. In my case, I was, the benefit of all that travel is I have those relationships. And so it's been easier for me to do what I need to do remotely. But I think a lot of these things are here to stay, and some are improvements. I found that court arguments, for the most part, are fine remotely. And sometimes you can even see the judges better and see their reactions if they're not too small on the screen. Working with documents on a screen, small screen is awkward. If you need to do that, that's a negative. And I think if it's an appellate court, the judges tend to lose their own interaction with each other, which I think gets in the way of communication. But overall, the arguments, I think, have worked well. We've had remote depositions, a lot of them. That's, there are issues with remote depositions, but we got it out of necessity. Otherwise, discovery would ground to a halt. There's definitely some problems. It's hard to prepare a witness. It's harder, I should say, to prepare a witness, particularly an inexperienced one, if you're not in the room with them or there to sit down and go through the important documents with them. It's harder to protect a witness from an abusive or bullying questioner if you're not in the room with them during the deposition. If you're taking the deposition, can't always be sure what the witness has in front of them, whether they're getting texts or things like that. There's potential for abuse. I think all of those things can be addressed through deposition protocols. And one of the things I've noticed is that an incredible amount of time is going into negotiating those because people are, feeling their way through. It's their new problems, and they're figuring out what they like and what they don't like. I think eventually there will be best practices that are developed that are fair to both sides and that may eventually get adapted into rule changes. Because I think these kinds of depositions are here to stay. It's just economically much easier on the client, particularly in cases with a lot of lawyers, to have a good amount of remote participation, and whether you can justify the expense of traveling across the country for a deposition becomes a different question. So that's...
Yeah, it's interesting. I'm curious, and I could have asked Janet this question too. So if you do depositions by Zoom, it's very easy to record them. You don't have to arrange to videotape the deposition or anything like that. You really could have almost like a standard practice of having video records of depositions. And my recollection is that not every deposition has been recorded in the pre-COVID era. I mean, you think that's something that could emerge from this?
Potentially with the right technology. I don't know what the editing capabilities are with a Zoom recording, but certainly, it's commonplace to record depositions now, and this could be a lower cost way of doing it. Again, I think you need to address the safeguards in the rules, and this might be an area where the rules would be adapted like they were for ESI when ESI came along. But there's a lot of cost savings from remote depositions that people are going to have to, reckon with.
Great, thank you. So let's turn to Judge Pearlman.
Can I just weigh in on that real quick?
Go right ahead. Yeah.
Okay, we had the opposite situation come up where we were representing some women whose images had been stolen. They were professional models, and we had a settlement conference scheduled by Zoom. Well, they didn't want to participate. And we ended up talking with the clients and figured out they didn't want to be recorded in these sessions and have their images stolen again. So we actually went to the judge about it and got a court order that no one could record the Zoom meeting, which was the settlement meeting, because that was really the whole crux of the case. So I just wanted to throw that in, that it kind of cuts both ways.
Yeah, sure. There are situations where it wouldn't be appropriate. And so we'll come back to this. Judge Pearlman, so you're presiding over a lot of civil cases and you're doing a lot of pretrial proceedings. How is what about the Zoom era has been a positive from your perspective? The Zoom era, the COVID era.
Well, one of the things that I really love about Zoom, or I guess, yeah, about Zoom, is that I think it really humanizes the profession and the attorneys. I mean, if you think about it, we are entering people's homes, their living rooms, their kitchens. I mean, I know some of you are, looks like you're in your office, and here in Florida, specifically South Florida, I think it's only recent that people have gone back to their offices. But, we started Zoom, I would say, in mid-March. And so we were entering people's living rooms, their kitchens, we were coming into their homes. I was coming into their home, they were coming into my home. And if you think about it, that automatically breaks down some barriers. So what I started doing, like, for example, if Charlie had appeared in front of me in a case, I would say, Mr. Lifflin, have you read all those books? I talk about people's backgrounds. I mean, I know it sounds, I don't want to say silly, but if you take a moment and you pause, if you think about it, every time an attorney came into a courtroom, for a 5-minute hearing, they say their motion, they leave, you get a ruling, and that's it. But here, because we're going into people's homes, you have artwork behind them. Sometimes I ask them about their pictures. Sometimes their kids show up, they sit on their laps, and I say, oh, let's, who's your new co-counsel? So they have their kids' artwork. So I really think that it's become a little bit more personal and a little bit more humanizing. I also echo Charlie and Janet's about the efficient use of time. Because we don't have any trials, you could land a 747 as far as on my calendar about hearings. You want an hour-long hearing? You want a 3-day hearing? You want a 5-day non-jury trial? Whatever it is you want. We have all that time. Before, when we had jury trials, I would have like 3 weeks of jury trials, and then only like a week or two of hour-long hearings or 30-minute hearings or whatever. So if you didn't get in that period, you had to go to the next month. Now, if you want a hearing next week, I can squeeze you in Monday through Friday. It's great. It's a lot more efficient that way, and it's certainly a lot easier to get the attorneys to appear on Zoom. If you see the emails going back and forth, they're fighting about, as you all discussed, discovery or pretrial matters or whatever it is. I'll just ask my assistant to say, hey, have them pop onto Zoom tomorrow morning and, let's talk about it. Let's have a status. Let's have a case management. So that part has been very efficient.
So you can use the additional time that you have to be a more active, more hands-on case manager.
Yes, insofar as what the other panelists have discussed only gets us so far, because we all know there's nothing like a trial date to move a case. Right. So yes, only up to so far, yes.
Goes to the point that Janet made about if you don't have a trial date, it's kind of hard to get to the end of the process. And yes. That, and we'll talk about that in a minute when we talk about negatives, but that certainly is one of the ones that's kind of looming over this whole conversation.
Can I make a quick comment on what the
judge
said?
Yeah.
First, I have to say that when I argued before Judge Breyer last month, he asked me exactly that question: have I read all of those books in back of me? The answer, I'd be lying if I said yes, but a good number of them. The other thing is, just going to your other comments, we have magistrate judges who have ordered that all meet and confers be done by Zoom rather than by telephone. And one of my partners commented to me that really does, in her view, make them more productive. People are more inclined to be reasonable if they're looking at each other on the screen. And the home factor as well, she says, she has a 6-year-old daughter who occasionally disrupts things. And when you see that happening to opposing counsel, there's a human connection there. It's an opportunity to be civil, was the way she put it. And I think you're exactly right on that.
Mm-hmm. Great. So, Scott, you're looking at this as academic and you're looking at civil litigation writ large, what do you think? What have been some of the positives from your perspective?
Yeah, let me make 4 quick points. Not having to travel, I think, is a huge one. I agree with Janet and Charlie. Travel is costly. It's burdensome in terms of time. It exacts a mental toll. As one lawyer told me with a very wistful sigh, imagine no more air travel, car rental, possible hotel room for a routine client meeting or a 26F conference, no more traffic, courthouse parking, metal detectors, thick briefcases for a status conference. So I think that's a big deal for practitioners. Travel can also make scheduling difficult. So sort of in line with what Judge Pearlman just said, Judge Rosenthal told me that scheduling status conferences is way, way easier when Zoom is available. So I think travel benefits are huge. They're especially large with cases with an international dimension. You still have to worry about time zones, but at least you don't have jet lag. 2, I think virtual meetings, especially like strategy meetings and client meetings, can be way more efficient. They can be crisper, shorter, more focused than in-person meetings. I know this firsthand with faculty meetings. And gone is the pressure, I think, to complete the task in a single continuous meeting, because you can break it out into several sessions with hours or even days in between. So I think remote technology really makes meetings flexible, more efficient, and often more effective. In terms of flexibility, so a 3rd point, I think, is how flexible it is. So say a lawyer is on a client call talking about discoverable documents, and the client wants to show the lawyer just how complicated it might be to find certain emails. Well, the client can share the screen and actually show the lawyer her email folders. Or say in a strategy meeting, the team suddenly realizes that paralegal Bob and client IT director Jane have useful information to share. Well, you can just patch them in from wherever they happen to be. A 4th point, I think, is court access. And I think this is a really important one that often gets overlooked. The open courts norm that we have is usually an in-person norm, which comes with significant limitations. But video conferencing technology for courtroom proceedings can expand public and media access to proceedings greatly. Courts have put remote viewing access links on their websites and have publicized remote access using social media. And these kinds of efforts have the potential not just to preserve the open courts norm in a state of a pandemic, but to expand it in a transformative way. Approximately 500,000 people listened live to the Supreme Court telephonic oral arguments held last spring, and nearly 2 million have listened to the recordings online. That's vastly more than the physical seats allowed to be filled in person. So, I think the video conferencing option has a lot to recommend it, and I think it'll be increasingly demanded by clients, lawyers, and judges, especially when the cost-saving opportunities are high and the efficacy of the interaction can be maintained.
Right. So there's a transparency piece to this, which is not so much about the interests of the folks on this call, but it's a public interest, that it's in seeing what the courts are doing. And something else I've heard, and we can talk about this in a little bit, but for clients, particularly clients who have modest means, the availability of a video participation actually can make a big difference. And there's some data, and maybe Judge Pearlman can comment on this. In the smaller cases, like eviction cases, debt collection cases like that, what so far we have found is that more people show up because they don't have to take the time and spend the money getting to court to defend their case. So there's it's been a significant decrease in the number of defaults, and that kind of goes to the same issue of public access that you were talking about. Well, so I want to say 2 things before we move on to the next topic. We had a couple questions about, I think, really going more to trials. And I think we'll pass on those because this panel is not about trials. I think there's some good questions pending about trials. We're talking about pretrial here. But I will also point out we're going to have a Q&A period at the end. So if we don't get to your questions now, we'll get to them before we're done with the panel. There is a question that we can add, and it's from Judge Kuhl in Los Angeles. And the next topic we were going to talk generally is what are some of the negatives about this particular period in time and how it's impacted the courts. And Judge Kuhl's question really goes to the relationships between counsel, and the feeling on the part of some judges that counsel may not be getting along as well, because not only because of the remote process, but also because of the stresses of the time, just that people are having a hard time just getting by in the times we live in. So we can weave that question into the comments that each of you have. But I'm curious, what would you call out as being the major negatives of litigating in this era? And we'll go back to Janet.
The biggest negative that we are seeing is the ability to meet with our clients and prep them and to be with them in the depositions. And since we do represent individuals, mostly products liability or other kinds of personal injury cases, the people aren't necessarily sophisticated in terms of using technology. Some of them don't even really have access to it. So we have people who have flip phones. We can't even do, a FaceTime on an iPhone. They don't have them. So we're really kind of grappling with how are we going to prep these people, and especially if they're not local, because some of our clients, from all over the country. And we've been concerned about it. When we've had a variety of fact patterns develop, we had one where a local plaintiff was ready to be deposed. The defense counsel said they wanted to do it in person. And we said, well, if you're going to do it in person, we can do it here in our office, but everyone has to wear a mask. So then they said, well, never mind, then we'll do it by Zoom. So we ended up having the clients come to our office, only the client had no mask and everyone else had on the mask, and it was done through Zoom. So that worked out fine. We have another case where the defendants wanted to take the client's depo, and we said, okay, well, let's set it up by Zoom. And, oh, no, it has to be in person. And they insisted on it. And with COVID and everything, we were like, look, this just isn't safe, because they weren't even requiring masks. We filed a motion for protective order with the court, and we lost. So we have to go forward with the depo of a plaintiff, and we're trying to grapple with how we're going to do this and do it safely when it's in a place where masks aren't even required. But on the flip side too, then we have these clients that we need to prep. So we're now looking at, do we need to fly to these locations? How are we going to get the clients deposed? And so we're looking into finding court reporter services that have the technology available. And that's really the biggest thing that I'm trying to do, is to not have the clients dealing with the technology. So I need to get them in a situation where there's somebody there who can handle opening the exhibits for them. And I don't want them dealing with all that. They need to focus on the depo. So that's really the biggest challenge or negative that we've been dealing with right now.
Just not being able to be with your clients and provide the support and guidance that you would normally provide.
Right. And then putting them in the position that they have to be experts on technology when they're not.
Right. And that's not just clients who have to deal with that. I mean, that's all of us to some degree. Right?
That's true. I know my weaknesses.
Charlie, what about you?
Again, I agree with everything Janet said. I mean, no ability to travel. You lose the ability to interact with people in person, which is so important in so many ways. Getting to know your judge, your adversaries, lawyers for other defendants, your witnesses, preparing your witnesses. I agree with that. Obviously, it helps if you already know them, but if you don't, it's a real challenge. You do lose a lot with the in-person factor. I mean, in my experience, a lot of important stuff happens in the hallway at a mediation, where you really get down to it and buttonhole somebody, or they buttonhole you. And the same thing in hearings and in trials. So that's something that you really can't replicate. I mean, you can pick up the phone and call people, but those kind of spontaneous interactions that sometimes really get to the heart of something and help get something done, don't occur that way. I also think a big negative for us is not being able to work in the office. We're a little different. We generally, most of us, we have a big office. We're working at home mostly. You can go in if you need, for example, a more sophisticated video setup for a court argument or something like that. But for the most part, people are at home, and that really has some costs. Training and mentoring, you have to work much harder at it. You don't have, the opportunity to go out for coffee with your colleagues and talk about things other than your cases, or help associates with cases that you might not personally be working on. Those are all things you have to work hard on, maintaining camaraderie, avoiding the negative effects of isolation. You have to work hard on those things. And, I'm lucky in that my children are all grown and I have an office where I can come and, work productively. That's not true of everybody, particularly people with small children and no help. They are undergoing a lot of strains, and so there's a lot that we need to address, I think, continuously. And of course, clients as well. It's keeping up with your clients, developing new clients, again, requires a lot more focus because you don't have the ability to just go and visit like you normally do.
Right. One of the questions that we have that we won't get to directly because it has to do with trial, but it had to do with the idea of confrontation. That certainly I think if we're talking about criminal cases, which is not really the focus of this panel, there are some significant issues there. But let me ask both you and Janet, in terms of the when you have an adversary process like the deposition, have you noticed a difference in terms of your experience of the quality of that, say between doing it in person and doing it remotely?
I'll go ahead. I've actually done a fair amount of remote depositions prior to COVID. We found, particularly with taking expert depositions, a lot of times I figure they've all been deposed a million times. Me looking them in the eye isn't going to make any difference. So we've done a lot of expert depos remotely already, and we're dealing with that. So I don't know that it's made a big impact in that regard to me.
Charlie? You're muted. There you go.
Right now.
Yeah, you're good.
So, yeah, I'd agree. I think it really depends on the nature of the witness and the nature of the proceeding. I agree on experts. It's probably less critical to do it in person. We had a Fry hearing in New York, or sort of a combination Fry-Daubert hearing in the opioids cases, where there were 6 experts examined, and there was every permutation. 4 of them were done remotely. 2 of them were live. We had the plaintiff's lawyers, who were local, were all in the courtroom with masks, and the judge was in the courtroom. Some of the examining lawyers who were not local examined remotely. In one case, one of them went in to examine a witness live who was there live. And, overall, there were some glitches. And like I said before, putting documents on the screen makes things difficult. But, overall, the parties were able to create the record that the judge needed on the experts, and the judge was able to see the experts. So I thought, it went fine. There are definitely some advantages to being live if you're in a true cross-examination situation. There are things you can do in a courtroom to, control attention that you just can't do over video. But for a lot of things, I don't know that it makes that much difference in terms of quality. And of course, you got the benefits of the lower cost and
right.
Avoiding putting your health at risk.
So I want to switch to Judge Pearlman. I actually have several questions that can flow directly out of this. If you're seeing lawyers in a virtual forum rather than in the courtroom, has it made a difference to you? I mean, do you feel like you're missing things? You're not getting the same quality of advocacy, or you're not picking up some of the nuances of the advocacy?
Well, I mean, as a presiding judge, the general answer is no, because, a hearing is hearing, a hearing is a hearing, a motion is a motion, and I take it just as seriously as if you were here in person or on the screen. But as everyone has been saying, one of the disadvantages is that we are sitting here staring at a screen. That's what we're doing. So it seems to have, it could be a little dull at some times. It could have a flat affect. I'm old school trial attorney. My career, I grew up in the courtroom. I was a public defender. I was a fighter. I did death penalty litigation. I was a deputy district attorney. I was in there fighting for the people. And so for the old school trial attorneys, I think it's more difficult for them to just sit in a chair and argue their motion. They like to use their hands. They like to get up. They like to walk around. They like to be expressive, have some passion, have emotion. And I think you lose some of that in the Zoom. I think the newer attorneys or the younger attorneys, I think, are having an easier time because they just come in, they do their motion, that's it, they're done. So I think that there's a difference between how the attorneys are perceiving it, and I think that everyone's getting used to this platform because, as Judge Kuhl said, and I wrote this down because she's exactly correct. We need to do whatever we need to do to keep the wheels of justice moving. And I have to say that the civil side of our circuit we haven't missed a beat. We started doing Zoom in the middle of March, and it has been nonstop. And so I'm proud to say that we have helped provide access to the courts and continuation. But another thing is that technical difficulties. We talked about that. That's a downside. Anything from bad signals. Down here in Florida, we have like almost torrential hurricane weather. I lost Zoom connection twice yesterday in the middle of hearings. And so, it's a little bit difficult sometimes. It's a little bit frustrating, but we're all getting used to it. Also, and this goes back to your question, Judge Fogel, and I think this is what you were referring to, is decorum. There's no decorum anymore. This is our courtroom. And so, not that I need people to rise when I stand into a courtroom. I'm not talking about that. I'm talking about the decorum, about how attorneys speak to each other. And this goes back to Judge Kuhl's comment about whether people are civil to each other. I started a new, so for example, my motion calendar, I could have probably 20 attorneys every morning. So instead of having people, yell, like I tell them, listen, you're like yelling across the courtroom. When you talk in open court, in open Zoom, you're yelling across the courtroom. But every morning it used to be, hi, I'm here on this case. Oh, I'm here on this case. Oh, hey, I'm here on this case. How you doing? Oh, wait, I'm the court reporter. So I started having everybody check in, like how you have the Zoom web, the chat. I started having people check in on chat so that it would say as if they're walking to the courtroom, they're checking in with the clerk, both parties are present, the court reporter is here, and then I call the case. But I'm trying to put in a little decorum. It's very challenging having attorneys try something new. But I just want to comment also, Judge Kuhl, I have seen a lot of what you are referring to. I think the inflexibility of the attorneys with regard to deadlines has been tough. People are not considerate with each other. They're not taking into consideration other people's circumstances, and we don't know what other people's circumstances are. Like we said, we started Zoom in the middle of March. We haven't missed a beat, but you don't know what's going on in other people's lives. Down here in Florida, the parents are trying to determine whether or not to send their kids to school. They're opening up the schools. They have kids who are grade school. They're working from home, both parents. They don't have the bandwidth. They don't have enough computers. There's so much going on. And plus, oh yeah, we're also practicing law. And I have a major, major case going on. Something's got to give. There's got to be consideration between everybody. And so when the attorneys come to me and say, oh, they canceled, I just had this yesterday. They canceled an examination by a plaintiff. And they didn't cancel within the 48 hours. And the plaintiff's attorney said, Judge, she's pregnant. She didn't get clearance from her doctor. And I turned to the defense. I'm like, come on. I'm not forcing someone to go get a medical examination when they don't get clearance from their doctor. I'm certainly not going to charge them or make them pay the $900 cancellation fee. I said to them, look, this is something you all can resolve yourselves. You do not need me to do this. But
you're making really a couple points here, I think. And one is that ordinarily that's the kind of stuff. Not that those kinds of things don't happen between counsel anyway. They certainly did before there ever was anything like COVID, but at least the chance to be with the other person physically gave an opportunity to interact, develop a relationship, and you're going to see this person again. You're going to be litigating with them over a period of time. So there is the thing that a number of you have talked about you don't have the benefits of the personal relationship. And then the other thing you've mentioned, which really is, I think, goes to the core of the question that Judge Kuhl asked, is, people have lives that are intruding on their practice in ways that they never did before this, that they're really trying to do several things at once. And there was a comment earlier about, you said it was actually kind of interesting to have the kids in the room when you were doing a status conference, and, opened up some opportunities for informality, but sort of the other side of that is if there's a serious argument to be had and someone's distracted or someone's home circumstances are such that it's just really hard for them to put all their attention there, sort of the bandwidth issue you just mentioned, that's a real challenge, right? And that's not something that's about to go away anytime soon. So you have you don't have the building blocks of good collegial relationships between counsel, and you have more things going on that can cause problems, is what I'm hearing. And one other question for you, as a judge, do you see a lot in your calendar? Do you see a lot of self-represented litigants, and how are they dealing with this new reality?
I don't see a lot of pro ses, but I think they're enjoying it. They're coming on screen like they're a star. They're able to talk, and some of them appear by phone. Some of them appear with video. Some of them, I've had hearings where they've been in their car, and I've said, listen, I hope you're not driving, or, please don't drive and Zoom at the same time. But I think, I don't want to say they're enjoying it, because I think that's the wrong word, but I think as far as access to courts, for those who have the ability and the technology, again, I think they are enjoying being on Zoom. But I have found that a lot of the attorneys, I've had to cancel a lot of hearings because what the attorneys are not doing is they're not including the telephone information on the Zoom, on the notice of hearing. And I'm explaining to them that, look, everybody doesn't have a computer. Everybody doesn't have access to Zoom via the computer. You have to include the telephone information so that if they don't have that, they could use their phone. So most people obviously have a phone, but I don't see a big difference in that, other than, obviously it's easier for them to appear.
Yeah, one thing I've heard is that, and you kind of touched on it, is that they like the idea that everybody's box is the same size. And instead of being in a courtroom where the judge is up above them and the whole architecture of the courtroom is somewhat intimidating, that in a Zoom hearing that everybody's on equal footing, at least in terms of the size of their window. So, Scott, what do you think of all of this in terms of the negatives that people have talked about?
Yeah, I'll just mention 3 cons that are going to echo a lot of what some of the other folks have said. The reports I get, and I think it makes sense theoretically, is that in an adversarial setting, document presentation, credibility assessments, and witness confrontation can be hard, not always, but I think it can be hard. A recalcitrant witness can be emboldened by the comfort and security of their kitchen table, and virtual examination can make it hard for the examiner to maintain control over pace and tone and to police the flow of information to the witness. So I agree with Charlie that things depend on the witness, but outside of repeat experts, I think it can be hard to know what kind of witness you're getting until you're in it. And as Janet and Charlie said, I think preparing for a major deposition remotely presents challenges, as does subjecting and controlling a witness during the deposition. So for contentious and important depositions, it may be that the lawyer's physical presence are really important to the integrity and efficiency of the deposition. I also think that document-intensive proceedings are difficult to replace with current remote technology, because I think it's still pretty cumbersome to organize and present large volumes of documents, especially in adversarial circumstances where the participants may not know in advance which documents or portions of them will need to be used. I'm pretty optimistic that some software platforms and hardware setups can pretty quickly evolve to enable remote viewing of both witnesses and documents effectively, but I think the setups and technology aren't in widespread use at the time. Another con, I think, is the possible adverse effect on decorum, and Judge Pearlman mentioned this. It's sort of the flip side of the humanizing informality that she noted earlier. physical courtrooms feature a judge in a robe, elevated on a bench with flags, the court seal, portraits of former jurists, even a formal cry opening the court, tradition of rising when the court enters and leaves, or when the judge does. And I think, these traditions of solemnity and formality are important. But I do think some simple steps can minimize the concern. So each participant, I think judges included, should make sure to dress in proper courtroom attire. Each participant, and again, judges included, should use a professional background like Judge Pearlman. Lawyers, I think, should name their virtual presence using real names, their firms, and their client even. And these kinds of norms can be written into the judge's individual rules or developed district-wide by local rules. So I think professionalizing remote participation can reinforce the formality and solemnity of the occasion. And the third con, I think, is the digital divide. As Judge Fogel just hinted, I think not every party can obtain access to the requisite technology. And not every party or lawyer has the same resources to devote to learning the use of technology effectively. So the digital divide, I think, is real. Many pro se parties and prisoners do not have hardware devices or remote technology software or access to that kind of stuff. And unsophisticated litigants and attorneys may not be facile with it to their disadvantage against a more sophisticated opponent. So I think judges should take the access burdens of remote technology seriously too.
Great. Well, thank you. So what I'd like to do next is go back to the panel one more time and just ask this question. At some point the pandemic's going to end. We don't know when. There's much to be said about that, but this is not a panel on epidemiology. And so when it ends, what should we look at from this experience is something that we ought to build into the system going forward. How can we learn from this and actually make the courts more responsive to their users and provide better justice on the civil side going forward? Janet?
Well, I definitely think having really close management on discovery, and I've had a couple of cases where that has continued and it's all been done remotely, has been very helpful to the case. It's moved the case forward. It's been easy for the parties. Nobody had to travel to get to the courthouse. I think it was easier for the court, although maybe I could be corrected on that, but I had the impression that it's quicker for the court too to do all this, in this case by telephone. And it's so the management has been very helpful and more cost effective. So I think that is the number one issue that I see that could really benefit going forward.
Using this video technology to deal with things like discovery disputes, issues, just case management issues generally.
Yes, in video or just telephone calls instead of always having everybody go in person. And again, maybe you do it every fourth time you come in person. I mean, there might be ways to do a little bit of both because you are, again, losing all those interconnections. But the cost and the time savings, I think, are very significant.
Yeah, I know as and Judge Pearlman may have some thoughts about this too, but I know when I was presiding over civil cases that the lawyers would come in and they would tell me what had happened somewhere else. And of course, it was night and day, right? I mean, and I spent an awful lot of time trying to figure out what was true. And in a way, it would have been really easy to just have, here's the question, here's what happened. Take a look at it, Judge. It would have been pretty easy, and I think it might have changed the way the lawyers were interacting too if they knew that everything was going to be transparent in that way. So that's, certainly my thought about what you just said is that it could really help, particularly in the area of discovery. Yeah, Charlie.
I think generally. Janet's right. I think we're going to take the best of what we've learned from being forced to use this technology, which does enable a lot of efficiencies, and continue it forward. And I think the technology will get better. I mean, I can only imagine what it would have been like if COVID had hit when I started practicing in the 80s, and there wasn't even an internet. Everything would have ground to a halt. And my guess is if it happened 20 years from now, we'd all be talking about how can you believe that we were able to keep going with just Zoom. But I think the remote proceedings, video proceedings that are able to be done on a laptop are going to be used a lot more, because as the clients or the litigants will not want to incur the expenses of travel and the inefficiencies that have made litigation so expensive so far.
Do you agree with Janet that there ought to be built into that occasional opportunities for counsel to get together?
Oh yes, I think you'll have more efficiency replacing some of the travel. I mean, who wants to travel across the country for a status conference that turns out to be 15 minutes? On the other hand, for an important joint defense meeting, you get a lot more done in person. So there's a balance to be struck, and I think we'll see it, moving toward the more efficient while trying to preserve what's really essential in the in-person interaction.
Judge Pearlman, what do you think? How do you see these system changes going forward?
Well, I agree with everybody else, is that I think remote technology or remote court is here to stay. I know that I will continue to use Zoom I have a uniform motion counter every morning, and those are for 5 to 10 minute matters. They're for quick discovery matters and other type of motions, motions to compel, motions to produce. And so we, in Broward County, we have a lot of people who commute. They call it the Tri-County area, almost kind of like the Bay Area, except we don't have BART. We have no mass communication here. It's called I-95. And so people drive from Miami all the way up to Palm Beach. They go to Fort Lauderdale, they go back and forth. And before COVID or before Zoom, I get a call every morning saying there was an accident in 95. I mean, duh, of course there's an accident in 95. And we have a train. We started a train, Brightline started. But anyway, my point is that I think that this is definitely going to help. I think people who live in Miami are not going to travel up to Palm Beach anymore to attend a 5-minute or 10-minute matter. I plan on having Zoom for that purpose. And I agree. I think it was Janet that said that it's a lot easier to just get the attorneys together on a status on Zoom instead of everybody coming in, especially if there's attorneys that travel or clients who need to travel. No more motions to have the corporate rep or someone not have to appear at a mediation because they have to come in from out of town, or that cost is gone. They can attend by Zoom or remotely. So, and I also think that we have to start thinking out of the box. I mean, I know that this panel isn't necessarily about trial, but I listened to the last panel, and I think that everybody's in agreement that we need to start thinking out of the box about how to continue the constitutional right to a jury trial. So, that's also remains to be seen.
Let me ask you, in terms of motions, I mean, status conferences, I think there's a pretty broad consensus that if it's a 5 or 10 minute status conference or a case management conference, that virtual technologies really are pretty positive. What if it's a summary judgment motion or a meaningful motion to dismiss or something like that, where the case could be ended or it could be substantially affected substantively by what you do? Thoughts about that as a judge? Would you want those in person? Are you okay with them being virtual? I mean, how do you break that down?
That's a great question, Judge, because my brother is a practicing attorney in the area of bankruptcy. And I can tell you, for a judge, it makes no difference. I mean, I take it as seriously as if we were in the courtroom. But as a practitioner, because I got this question from my brother, he's like, I have a very important summary judgment. I'm supposed to do that by Zoom. And it was interesting because from a practitioner's point of view, I think maybe they see it as a less important forum. I think Scott was talking about, the decorum and the professionalism, and you lose that. But I mean, as a judge, I don't take it any less seriously. And I reread everything ahead of time. I'm prepared for the hearing. It's the same as if I was in the courtroom. But I think the practitioners, I think the lawyers look at it differently, and they may feel that it's not taken as seriously or as important as if they were in the courtroom.
Mm-hmm. Well, let me double back to our lawyers. What about that? I mean, if you had a major motion, a substantive motion in one of your cases, how would you feel about it being heard virtually as opposed to in person? Janet?
Well, I can comment on that.
Charlie, go ahead.
Go ahead.
I was going to say, I've noticed a trend in the federal courts, even for summary judgment, and a lot of some big motions, that courts are often deciding them on the papers and not holding arguments.
Mm-hmm, mm-hmm.
So if the alternative to that is Zoom, I'll take the Zoom. I do think for important motions, it's nice to be able to, really address any nuances, have an opportunity to see if the judge is really getting what you were trying to do, or if you've overlooked something, if there's something that needs to be addressed. I think, that's kind of the function of oral argument on motions, and you lose something by not having it. I'd prefer it to be in person, generally on an important motion, because you have an extra ability to communicate with the judge, but I think Zoom is better than nothing.
Yeah, and you're right that there certainly is a trend in a lot of courts to either not have oral argument at all or have it be very, very limited. So maybe it's a middle ground. Janet, as a plaintiff's lawyer, what do you think?
Yeah, I agree. I think I might even be tempted to set up some kind of a podium so I could be standing up when I address the court, just because that's how I'm trained to do it. And I think I would feel more as if I was making a formal argument if I was in the right posture to do it. Whereas I'm sitting in my chair, I'm kind of starting to lean back and getting a little too casual. So that I would probably invest in something to make me feel more official.
It's back to the norms that we were talking about a little bit ago about if you're going to make this permanent, you might want to have some rules. Scott mentioned a couple things about the way you present yourself and dress codes and backgrounds and things like that would create a heightened sense of dignity and it would be less haphazard.
Can I just comment on that, Janet? I have had attorneys who actually have, and it's funny because I'm sitting now, but I usually stand during motion calendar because, well, for other reasons, it's sitting too much. But I've had attorneys who actually want to do their argument standing up because they feel more comfortable. And also, and this goes back to what Scott was saying too, about decorum and how things are different remotely. When the COVID first started, again, we don't know what's going on in people's lives. I didn't really care what people wore. I didn't, you just come on Zoom. It doesn't matter. Again, we were trying to do business as usual so that we can continue with the justice system. People would come on, especially I'll talk about the women. I remember the first time someone showed up. I don't usually wear makeup, I should say, on Zoom because I'm wearing makeup now. I shouldn't say that, but I remember talking to the female attorneys about, and they would say, "Oh, it makes them feel better. They're dressed. It makes them feel like they're going to the courtroom. It makes them feel better." Now I think we're all used to it, but I think this goes back to what Janet was saying about making your argument. They were standing up. They wanted to make their argument like they were in the courtroom. And I think that makes them feel like they're in the courtroom.
So maybe some protocol that would get you as close to a in-person experience as possible would help narrow the gap between the two. I will say that the appellate judges I've talked to who are doing nothing but hearing argument like it. I don't know too many appellate judges who object to Zoom, except for the ones who aren't comfortable with the technology. Their main complaint is they don't get to see their colleagues and they don't get to see their law clerks. And so there was that comment that Charlie made about mentoring and those kinds of relationships. But the actual arguments, they're in general pretty content with them. Scott, what do you think about this from the overarching perspective?
So I think, litigation rules and practices have always balanced cost, efficiency, and justice. And I think The pandemic has fueled innovation and experience and familiarity that I think will shift that balance towards video conferencing in more situations than were used pre-pandemic, especially when the stakes are low. I think to continue to shift that balance, a few other things need to happen. First, I think we need to foster a working partnership among the bench, the bar, and the legal academy to develop rules and standards for post-pandemic adoption of routine use of video conferencing technology and what that would look like. So thank you to the organizers of this conference for kicking that off. Second, I think we need a uniform or at least universally compatible, widely accessible, relatively easy to learn, functional and secure technology. A technology that's also, I think, flexible enough to accommodate the diversity of litigation practice and cheap enough to make the game worth the candle. So although I think that sounds like a tall order, I think there's reason for great optimism here. I agree with Charlie that the technology will get better, and we've adapted to video conferencing extremely well during the pandemic. I haven't done litigation using it, but I've been teaching using it, and there have been great strides made in the last several months, even there. And third, I think we need more experience with remote technology to normalize it among a much broader swath of litigation culture, and more training to make sure that its usefulness is maximized while mistakes are minimized.
I'll just add a piece here. I remember when this all started back in March that I think a lot of us thought it was going to last a couple of months, and then it was going to get better, and maybe we would have a second wave in the fall. But I don't think that the conventional wisdom back then was that we were looking at anything near as long lasting as we're facing now. And I remember the federal response was the administrative office issued a couple of orders that suspended certain rules and allowed the use of virtual technology. But it was very clear this was temporary, and as soon as the emergency is over, we're going to go back to business as usual. And so the notion that it was just that it was anything more than a temporary accommodation to get us through a short period of inconvenience, that's kind of the way it was framed then. And I think now it's pretty clear, that we're maybe not even halfway through it, and that there may be some longer term results that would need the kind of very careful and thorough thought process that Scott was just describing, that this is going to be part of our culture, and so we need to take it seriously. We need to make it as good as we make everything else, or try to make everything else. And it isn't going to be haphazard, and you're not going to have hundreds of different ways of doing it. You're going to have some norms and some regularity, and really try to make it as much of a quality experience for everybody as you can. And I don't think we're there yet. I mean, I think we're still in this sort of transitional period where it's sort of, it just keeps evolving, and we keep seeing that this may actually end up going on for a long time, and the world may look very different afterwards. And that requires a kind of serious focus to process that we haven't really been able to put on it yet, because we're still just trying to deal with the crisis. So with that observation, I just ask if anyone else, before we turn to questions, whether anyone else has any thoughts along those lines. They're sort of more global observations about where we are. Anyone on the panel?
I would just add that some of the court reporting services have already come out with some very good products to have the deposition exhibits put into sort of a dedicated Dropbox that works with your transcript, and it's all confidential. And so some of the technology is coming along pretty quickly.
Mm-hmm. Yeah, there is an interesting thing we haven't really talked about, and it's not really germane to our overall topic, but the whole idea of court reporting, when you have virtual recording or virtual presentation of hearings, and what happens to that, and what happens to court reporters when you do that, when you have a video record. So it's another one of those things. It's a system issue that's going to have to get resolved. Other comments or thoughts? Ann, you have questions for us?
Hi, just coming on here. Can you see and hear me?
Yep.
Great. We have one question. Has anyone had virtual court experiences with self-represented litigants?
Right. We'll go to Judge Pearlman.
Yes, I've had pro se litigants, and as I was saying earlier, and I think Judge Fogel, you brought this point up as well. They feel like they're on equal footing, and I think they actually it's like they're up close and personal with me, because if you think about it, when you're in the courtroom, you're up on the platform, and the litigants are down there. They're right there on the screen, right next to you, and they're able to talk to you. And so I've had some pro ses. In fact, I had a pro se this morning. There's been some difficulty getting her to agree to a hearing date for summary judgment. So I asked her to come on to Zoom. I put her and the other side in a breakout room and told them to discuss and give me some dates, and came back on, and we set a date, and I made sure, I said, Miss X, I just want to make sure that this is a good date for you. I want to make sure that you're able to appear and that you don't have any conflicts, and I want to make it convenient for you. And so, I always try to make them feel at home, or, so it's working out well.
The data from some of the states that have studied this, Michigan comes to mind. I think there's another, maybe Texas is another one. Actually quite positive feedback from self-represented litigants and people who are interested in that topic, that this medium actually is more less intimidating and more amenable. So just something else to think about. Anything else, Sam, that's from the group?
Yeah, we're asked some questions about whether some of the distractions and other things that are going on are grounds for a mistrial. I don't know if there's more to say about that. Well,
so we're not talking about trials necessarily, but I guess maybe what we could do is put the question this way: has the informality that we've talked about already, has that caused any problems? Has it resulted in any awkwardness or even concerns about fairness because we don't have the usual decorum? Janet?
Well, I've had the experience when we were working at home in March and April of being at home and someone starts ringing my doorbell. I'm in the middle of a conference with a federal judge, and you're like, what do you do? It's echoing, and you go to the door with your laptop or what. Same thing, someone starts cutting the grass. So that can be distracting to you. You lose your concentration. And so that's one issue that, it's obviously a minor thing, but again, we all have to adapt because we can't control all of those interruptions. Or, my phone starts ringing every 45 minutes, somebody trying to sell me something for Duke Energy. It's just very difficult because I can't just turn off every single phone. So that's been a bit of an inconvenience.
Mm-hmm. Anyone else want to weigh in on that question?
I could, Judge Fogel. If you think about it, like Janet said, this thing threw us for a loop. Unless you had a dedicated office in your home, unless you had a separate room set up with a desk, the chair, the lamp, the internet, everything, everybody's trying to make do. They're in their living room, they're in their bedroom, they're in their kitchen. I can't tell you how many attorneys I see with their laptop at their kitchen counter. You could see their whole kitchen behind them. So everybody's doing the best they can, but we have life distractions. The lawnmower, I can't tell you how many times. It's embarrassing. I shouldn't say that because as a judge, they're mowing the lawn outside. I've got windows. I try to mute myself, when I'm not speaking, but life is happening around us while we are at home doing our Zoom hearing, and everybody just has to be a little bit more relaxed, but then that of course goes against the whole decorum and protocol, and we're not in the courtroom. So, there's pros and cons.
Mm-hmm. I'm not hearing anybody saying that there's been a real loss of fundamental fairness. It's more just something that's just kind of constantly something that has to be balanced.
I feel like,
Go Go ahead, Charlie.
I was going to say, I agree with that. I mean, I found that barking dogs are pretty ubiquitous on conference calls, but everybody's very understanding about it. And just treat the conversations professionally as you can, and it works fine.
Scott?
Yeah, I just add the same. Although I do think that a jury trial would present special circumstances.
Right. I think everybody on the panel agrees, and I know that others who have presented before and who are in the audience feel pretty strongly about jury trials being different. And certainly if you're talking about criminal jury trials, they're constitutionally different. But even civil jury trials, I think the expectations are different than what we've been talking about here. And one of the real background facts that we can't ignore when we're talking about COVID and pretrial is that if there aren't any trials, or if trials are very hard to pull off because of public health concerns, that changes the nature of the pretrial process pretty substantially, and what you're able to accomplish and so on. So we're almost out of time. Let me just ask if anyone has any last thought they want to share with the group, and we'll just go around one more time. Janet?
I think the main thing I would want to emphasize is I don't want to lose that opportunity to get to meet the court and the co-counsel. And if, especially at the initial pretrial conference, if we could have an opportunity, either do it by Zoom rather than conference call, or do it in person to the extent that's possible. If it's local people and you can wear a mask, I think there's a lot of value to that. And it helps set the stage then going forward that you might feel more comfortable with just phone calls or, the remote access.
Yeah, so that there is still something about the interpersonal contact that we don't want to just totally forget about in the interest of convenience. Yeah. Charlie?
Yeah, I think that's true. I think people need to be creative about finding ways to maintain relationships so that they can, do what's needed to be done to resolve cases. And it's clearly harder in this environment, but it just takes more focus.
Got to work at it a little bit harder. Yeah. Judge Pearlman?
Well, I think that, we can only take these cases, when I say we, I don't mean me, as a judge, obviously I'm just presiding over them, but the attorneys can only take these cases so far pre-trial. And at some point, like the other panelists said, and some of our panelists here said, they're going to need a trial date, and there's nothing that's going to move a case more than having a trial date. And like we heard at the last panel, there are litigants who are saying, hey, I'm not going to move the case because you're not going to get a trial for another year or a year and a half, maybe. So, and then we also have the problem that when the courthouses do open, I think as Judge Cole was saying, the criminal cases are going to have to go first because those have the constitutional trial issues. There are people in custody. And so what's that going to mean for the civil cases? So
Yeah. So at some point, civil cases will start to move again, and at some point that will change the dynamics of pretrial proceedings. And then all the points people have been making will be there, but the content of pretrial proceedings is going to be different if you have the dynamic of a meaningful trial date.
Yeah.
Scott?
Yeah, I'll just add that I think that maybe we'll see mediators and arbitrators really pushing the envelope here. I think there's been a lot of successes using video conferencing for mediations very effectively. And arbitration strikes me as the first frontier for use of it during trials because of its informality. And I think maybe arbitrators might be using it often in the future.
What I've heard from the private adjudication people is that their business is actually pretty robust right now because people who need to resolve their cases are going to them, and they're getting resolutions, and they're getting them effectively enough with virtual. It doesn't change the cost benefit that people go through if for whatever reason they don't want to go to trial and they know that the absence of trial dates is their friend. Then that could affect the decisions people make, and also the urgency people have about getting to trial. I know there was a problem in California that cases that are entitled to statutory priority, elderly plaintiffs and other folks who are entitled to statutory priority, I mean, they're not getting their trials in most of the counties, and that's a significant problem. I think we've covered the ground we intended to cover, unless our chair has any other questions for us. We are going to be taking a lunch break. And Ann, what is the time?
So we'll be taking a lunch break until about 1:15 p.m. During this time, the webinar will actually close, and we'll ask the attendees to log back in around 1:05 to participate in the afternoon panels. Thanks so much to this panel. You were fantastic. Really appreciate it.
Well, and I'd like to thank my colleagues for having such insightful contributions. So everybody stay safe and stay healthy.